You all know the topic. Some of you painfully know the topic, but I do think that you will all agree that it is extraordinarily relevant to us today. And so I am going to introduce our four moderators, or rather one moderator and three speakers, recognizing that our moderator is also an important speaker and contributor to today's discussion. Interestingly and not surprisingly, two of them are trained as accountants, two are trained as lawyers, and several of them have gone back and forth between banking and advisory work from a legal point of view. First of all, Brandon Abersold, who is with Lazard Frere in New York, who flew down specially for this, although he does tell me that he spends more than a few days a week in Houston under current circumstances. But Brandon is trained as a lawyer as well, is a retired lawyer from Simpson Thacher, joined Lazard, and has worked on a large number of restructurings. Most of them are detailed in your package, but I will highlight some names that you will recognize: Sabine Oil and Gas, Vantage Drilling, Hercules, and for those of us who have children, Toys R Us, Radio Shack, Lehman Brothers, Tishman Speyer, and the list goes on. Most would argue that Lazard is, if not the preeminent, certainly one of the best restructuring firms in the country today. Welcome to Houston. Our second restructuring expert of sorts is my good friend Becky Roof, who is, I do want to add and promote the fact that Alex Partners has just opened an office in Houston. Welcome home to Houston, Becky. Becky is a managing director there and has worked on a wide range of restructurings, oftentimes as interim management, and examples of that would include the fact that she served as a CFO at Eastman Kodak for many, many, many months up in upstate New York, CFO of Fleming Foods, Anchor Glass, Atkins Nutritionals, and the list goes on. She has been recognized across the industry, awarded by Women Leader, as the Women Leader in Consulting by Consulting Magazine, as well as the Turnaround of the Year Award for her work at Kodak. Welcome, Becky. Next, we have a veteran, Mr. Transier, Bill Transier. Many of you know him. He is one of those who has had a brilliant career, starting off as an accountant, doing very well there, turning into a CFO, then CEO, and now serves on a number of boards. I will mention them in a moment, but Bill brings, of course, the corporate experience, but also the governance experience to our panel today. He started off at KPMG, ultimately running their global energy practice, transferred into the industry by becoming CFO of Ocean until that company was sold, ultimately founded and led as CEO and chairman Endeavor International from 2004 to 2015, and I think he's going to walk you through some of the high points and the low points of that experience, and currently serves on a number of important boards, including Helix Energy, Stonegate, Paragon, CHC, and is a former board member of Reliance and Caldive. Quite a career. And finally, as I sort through my papers, Harry Perrin, who is joining us here from Vincent & Elkins. Harry has also had an interesting career going back and forth between law and finance, as he was a former partner at Petrie Parkman before they were sold to Merrill Lynch. Harry is a partner in the restructuring practice of Vincent & Elkins. He does point out also is a lifetime member of the board of the Houston Livestock Show and Rodeo. He is based in the Houston office and has worked on a wide range of restructurings, and we'll be happy to talk to you about his personal experiences. So with that, Brandon, thank you for moderating the show, and we look forward to your insights.
Great, thank you. It's good morning. It's an honor to be here. Let me quickly just frame the topic today, which I think is both rich and particularly important for this group. It's important in that restructurings entail an enhanced level of scrutiny over your decisions, as well as elevated potential liability for those decisions you're making. So with that enhanced scrutiny of your decisions, these are also complex issues that for the most part, most board members and executives, they don't deal with these issues routinely. Maybe one or two experiences in the area. So the framework of which this comes is you have an environment where there's really complex issues, you're stuck there, there's enhanced scrutiny over the decisions you make that entail enhanced liability, And these could be issues of first impression, and in most cases they are. And so I think today, hopefully with this conversation, if you do find yourself in a restructuring environment, they're not issues of first impression. And so the first topic that I want to cover is one that I've noticed in my career, is the one that board members, particularly those that have not been through a restructuring, but even those that have been through multiple, they struggle with the most. And that's this notion that your fiduciary duties can change, which very much is a legal question. So I'll start with Harry and ask Harry just to frame the conversation and the topic of, to whom are fiduciary duties owed and when do they change in a restructuring?
Okay, so as you observed in the typical corporate setting where you've got a thriving company that's not insolvent, the board thinks of those duties being owed to the shareholders. They're obviously the beneficiary of the surplus or the excess of the company over and above what's owed to creditors. And that duty, we all,
Your mic's not on.
Well, sorry about that, guys. Some people, well, there we go. Can you hear me now? I've had some clients said all they have to do is open the window and they can hear me. They don't even need to be as loud as I talk. So hopefully I won't be too loud with this on. Anyway, the duty is the shareholders are the beneficiaries of the enterprise. But as you get in an insolvency situation, that duty can shift. You still owe the duty to the corporation. It's owed to the company. It's not owed directly to the shareholders in the first instance. 10 or 15 years ago, there was this theory that when it shifted in the insolvency situation, board members and officers could be faced with direct claims by creditors. And you would see creditors threaten those fiduciary duty claims directly against those officers and directors to try to shape and influence their behavior. There was a Jiwala decision which came out of Delaware, I think about 10 or 12 years ago, which put that to rest and said, no, the duty is owed to the company. However, when you get into the insolvent situation, you have to consider the interest of creditors as you make those decisions, dealing with what's best for the company to maximize the value. So it is a shifting paradigm. When you get in that situation where you're creeping into what is typically called the zone of insolvency, you do need to start considering the interest of other creditors, of the creditors as well. Now, you don't ignore the shareholders, but you have to consider the interest of the creditors on the impact of those decisions. So it is an interesting, shift for board members. Most board members, I think, are raised thinking we got to do what's best for shareholders, and it is something that does require an adjustment in thinking.
Yeah, so it sounds so simple, right? That you're just maximizing value, and whether it's creditors or equity, well, their interests should be aligned. But Becky has a tremendous amount of experience with this, some real time. Maybe some thoughts on when you've seen this become manifest.
Well, it would be helpful if the creditors to who you now owe this duty would at least be nice about it. But they aren't. It's a hedge fund from New York who bought debt at 20 cents on the dollar and is now in your face saying, I own this company, you will do what I say. And you're like, no, not exactly. And so it really sets up a bad dynamic from the beginning often, and then, with activist shareholders, feeling like they can muscle their way in now too. It's really, really hard for a board member who joined a healthy company board thinking, never thinking that they would be in this situation. It's a very, very hard mindset to change. And this is where, and I know, Brandon, we've talked a lot about this, we want to get into this further, but having the right advisor and the right board set up from the beginning, do you have independent directors, do you have a lead director, do you do special committee, is critical, and it's something that's very important to think about sooner rather than later.
Yeah, it's an interesting point about how the advisors can help guide and tailor your behavior and let you know when to be cognizant of the fact that fiduciary duties may have shifted. Now, I'll give one quick anecdote. This was 6 months ago. You you enter what Harry referred to as the zone of insolvency. You have counsel give a presentation on here's to whom you owe duties and here's what it means. And a proposal comes in from these savages. Didn't Becky say that?
Pretty much.
The creditors in this proposal, and nobody likes it. But you get back to your office and you get an email from a director that says, I can't stand that proposal. It's terrible for equity.
Don't put it in an email.
Don't put it in an email. And you think like, well, what? We're maximizing value for shareholders. Why would that be inappropriate to put in an email, this is terrible for equity? Well, if you're in the zone of insolvency and later you're getting deposed and someone says, were you looking out for the best interest of the company or were you looking out for the best interest of equity, right? And it's very commonplace. I mean, your way of thinking in terms of maximizing value for equity, that shifts. And so, part of that, when you talk about, you do have a shift of duties. I mentioned earlier the enhanced scrutiny. In terms of potential liability, I'll open up to Harry or Bill. What are the risks of not appreciating that dynamic of the shift of fiduciary duties?
Well, I mean, obviously, you can be faced with an action brought, it'd be a derivative action, you'd have to be brought on behalf of the company. I think maybe perhaps a more relevant answer for board members is, how do you manage or mitigate that risk? And it gets back, I guess, to the process point, which Brandon mentioned earlier, and that is that you have the right advisors in place, restructuring advisors with relevant restructuring experience, relevant industry experience, and get the right lawyers in place as well with the same relevant experience, and that they make a good record of considering all the options and alternatives available to the company and actually consider any option or alternative that came in. Now, obviously, that email that you mentioned would be a horrible email that would be a trial exhibit in court whenever that disgruntled creditor wants to challenge why that transaction wasn't pursued. But if you have advisors that really run the process right, consider all the options and alternatives, make a good record. And one of the things the courts focus on was a thorough process run? Was there a good record of it? You don't have to make the right decision. You just need to exercise an informed, good faith, disinterested decision based upon a good record before you. So that's, maybe didn't answer your question directly, but that's how I would manage that. Because I think what we're talking about is managing the risk of officers and directors as they go through this process to make sure they do the right job.
So hopefully we're trying to tease out here how the environment is different in a restructuring context, starting with your mindset changing to now to whom do you owe fiduciary duties? Not typically a question you have to ask yourself as a director. So the role is changing, and I'll get Bill's thoughts here because he has a lot of experience both as the executive and on boards. And maybe Bill, from your perspective, going through a restructuring, what's the biggest change in terms of the role of board members?
Yeah, and I love listening to this conversation up here because this is the kind of stuff you'll hear as a board member, and I want to try to bring it down to a practical point of view. The first thing is, from my perspective, is that you have to be prepared long in advance of maybe going into a Chapter 11 process or any kind of restructuring process. And my impressions and experience, unfortunately, over the last several years is that there is a huge gap in knowledge on management teams and boards of directors that have actually been through a restructuring and those that have not. I had the luck, as you heard earlier, of being a KPMG partner and did a lot of finance and work. I was a chief financial officer, and then I was a CEO. I knew nothing about going into a restructuring process when my company had to go through it. And one of the things I would tell you is that there's a lot of things that can be done to get prepared up front. Now, Brandon and Harry, have both attorneys, talked about this zone of insolvency and these words that scare boards to death about where they're at. My view is that you have to be prepared. One of the things boards and management need to do is they really need to understand what they think the value of the company is, because that begins to set up the negotiations with the creditors. And if you don't have value there up front, then you can say, okay, my responsibilities begin to shift. But one of the things about business judgment, if I can just bring it back to practical point of view, is if you as a board and as a management team that you're leading sit there and focus on preserving value or enhancing value, my guess is that your business judgment will not be questioned at the end of the day. Harry's absolutely right. In our case, at Endeavor, we had counsel and restructuring financial advisors involved almost a year in advance because we knew the problems that were out there. We were a smaller company. We knew if they had any more hiccups in the North Sea where we were at, we were going to have a problem. So we created a long record of education for our board, got them prepared, and when we actually then began to negotiate outside of the Chapter 11 process on a consensual basis, the hope was, one of the things about going through a restructure, depending on the complexity of your capital structure, in our case, we had 5 different stacks of capital that made it very complicated. And each stack has their own mindset about what they expect to get out of this. And remember, it's not like herding cats. It's like herding a whole herd of buffalo, trying to get them into the right spot and negotiate with all of them so that eventually you can come up with something that everybody agrees with. So creating a record, also knowing what your business really is, having some sense of what the value is, and that begins to put you in a position where you know this zone of insolvency that these guys kind of talk about.
I think once you can figure out the value, then everybody, you can figure out the capital structure, secured versus unsecured, kind of come up with a waterfall on where value shakes out. I mean, making sure you've got a good handle on value, and there's a consensus around value even with the creditor groups. It's important to get that done, which goes to your point of planning as much ahead of time as you can, getting the right creditor constituencies organized and getting them to have advisors to work with you on that value proposition, and then how the distribution of value works under the various capital structure of the company.
Most of us in here have been involved or may be involved in the energy business and trying to set out a valuation proposition in today's environment, thinking about what the business should look like 2 or 3 years out, is really hard because it's everybody's best guess about where commodity prices are going to be and how the industry is going to come back and stuff. But if you haven't done that as a board, and I would venture to guess most boards have not really sat down with management teams and gone through that exercise where they take a hard look internally at themselves and say, what do I think the value of this business is? They can put their own projections on it in terms of future commodity prices and future costs of the business and stuff like that. But we just don't do that. Public company boards, a lot of time you look at these analysts' numbers and we kind of accept that and say we're trading in a range of 2 or 3 times cash flow or whatever the numbers are, but they don't really dig into it and understand what's there. And that's really important as a board, I think, to get key.
To follow up on that, do you think that your board and then experience with other boards, that they're realistic about that value proposition in a declining environment? It's very different to assess potential future value of your cash flows when you have an upward trajectory. Oftentimes these are in a downward trajectory. Was your board realistic about where you were?
Well, first of all, management CEOs are never realistic about what the value is. We're always undervalued. We're always undervalued, and it's always going to get better and stuff. And you bring up a really good point, Brandon. I have seen this over and over again. Every single group, management and board, go kind of through the same cycle. The first part of the cycle is denial. I'm not really in this. Things are going to get better. It's going to save my company and stuff. So I'm just going to hunker down and kind of hide away from it for a while. And then they get to the kind of the realization stage that they say, man, I'm going to have to deal with this because it's not going to get any better. And then there's this kind of, oh my gosh stage that all of these people come after us for all this information, and the process takes a ton of time longer than that. And then the final stage, which is the most risky, I think, for us on boards, is when the management and board just turn over the process to the advisors, and they just become observers to the process because they don't really understand it, and they just want to get out the other side. And that's really a dangerous part of this process.
That is a dangerous, because I mean, one of the things that the board and management are supposed to do is challenge their advisors on all their assumptions driving, their models or their evaluations or whatever the options they're presenting. So, look, it's an unpleasant experience. Brandon's very eloquent the way he described it. I just describe it as a land of broken promises. I mean, you've got all these creditors who had all these expectations and all these agreements, and you're breaching them, and so everybody's dealing with very disappointed expectations. You got employees that are, scared about their job. You got some regulatory authority that you didn't even know you had problems with. You've now shown up on their screen. So everybody is attacking you from every different direction, and I think a hunker down is sort of a normal reaction. But I think the key is to get a team in there early, really plan this thing out, and if you run it right, it can be a value maximizing, constructive process that comes out of it.
But I think the board really has to pay attention to management and how it's supporting management. Being the CEO and the general counsel of a company that's going through this is a very lonely job. And you are trying your best to satisfy all the requests that are coming in, all the meetings, and at the same time run the company, because the best prospect is a company that can run itself well, hold its operations together, and prove that it has a future. And back to the comment on advisors, yes, advisors can take control of the process. We all know each other. Most of us have been working in this business for 20 or 30 years together. Maybe not you, but I have.
What do you mean I have gray hair?
And it's not uncommon for us to be in a meeting and actually, greet or hug, the advisors to the other side. And that's hard for a company and a board to understand. So, you have to remember the advisors are working for you. And if you've got an advisor who is not keeping you informed, not involving you in decisions, and is just out over his or her skis, you've got the wrong advisor. And boards and management should not be afraid to push back on their advisors and say, wait a minute, why are we taking this decision now? Where is this leading us?
Yeah, advisors have come up multiple times. I think this relates back to the fact that these often are issues of first impression for boards. Bill mentioned management and the board pushing the decisions off to the advisors, which obviously is not the right approach. But I'll come back to Becky and say, all right, so we have these advisors here. We need to rely on them because these are issues of first impression, but we don't want to push off decision making to them. What should a board and a company expect from their advisors?
Well, I would ask the advisor, first of all, if you don't feel like you've got the right cultural fit, and I think a lot of times when advisors are being interviewed, management and boards don't think about, is this someone that I want sitting next to my CEO day in and day out for the next 6 months, year, whatever. And so I think it's important to make sure you have the right cultural and personality fit in the first place. Then, I really like to help a company organize its internal, restructuring committee so that not everybody in the company thinks that they need to be involved in the restructuring. I like to tell people, if you're doing something that you're not going to be doing after you emerge from bankruptcy, you shouldn't be doing it. Please focus on your day job, your operations job, and let us, take care of the noise of the bankruptcy. or the restructuring, doesn't have to be in court necessarily. We always organize a vendor management committee from the get-go, because the longer you can keep your suppliers on board and supporting you, the less cash you're going to have to spend, the longer runway you have to develop a plan and put it in place. And so we just find that that's, helpful from the beginning. And then we set up, daily calls, weekly calls to keep everybody informed. And these are advisor management calls, and then we immediately report out to the board.
To build quickly in this advisor dynamic, and from the perspective of a board member, what's the biggest surprises? What's the biggest surprise in terms of that interaction and dealing with your advisors from either management or the board?
Well, I think I mentioned it first a minute ago. There's a huge gap in knowledge between, and most boards don't know anything about a restructuring process. And then, so the temptation is always, once you see that you're going to need to do something on a restructuring basis, is to rush out and hire an advisor. I think Becky's advice is great in terms of finding the right fit. And we got 3 great firms up here that know this, but not all advisors in the restructuring process are created equal. You got to remember that this industry is used to kind of going through a process. This cottage industry called the restructuring business is used to going through a process of restructuring debt and companies and bringing them out the other side. The upstream energy business, the upstream service business, is a new phenomenon for most of them over the last couple years. I mean, they worked on a lot of different industries. They came to this, and I say this in the kindest way, they don't really understand the business as well as management does and stuff. So you need to be careful about who you hire up front. There's always a board member that says, I know Jim Bob over at such and such firm, and that may not be the right answer in terms of that. We interviewed several different firms, got a fantastic law firm involved, got a good financial advisor involved, and like I said, they were involved very early on in the process for the board to kind of get to know them. One of the suggestions I might make is that you have to stay involved as a board in terms of what's going on, and that doesn't mean just to show up at a meeting and hear a report from Becky or from Brandon or from B&E and Harry and stuff. It means really being involved. So one of the suggestions I would make to you is that if you don't have a special committee on the board, set one up. We did that on the company I'm involved with now, a drilling company, where we set up a finance and risk committee, and their job is to be involved with these advisors full-time so that we can make a better report back to the board, and they're involved in all the issues that are up there. Remember, the boards don't really have a knowledge of what's going on, and it's an easy temptation, as we've already said a couple times before, just to kind of stand back and let the advisors run this. You will not get the best answer for the creditors or the business if you do that and just cede that responsibility to those other folks. You need to be involved. You need to make sure that they really understand your business. I think as to the surprise, and then I'll turn it back, one of the surprises that you have is you don't realize how much is involved in building consensus around restructuring, particularly when you have a complicated capital structure. You don't realize how much it's going to cost to you, because every piece of the capital stack that's out there is going to have their own legal advisor, their own financial advisor, and maybe another firm involved in doing stuff for them, and you're going to end up paying for all of that to get through the restructuring process. And you start getting these engagement letters in and all this other stuff, and there's this denial stage, and you say, this just can't be happening to me, and that becomes a real eye-opener for the board and the management team to understand that.
Yes. I think one point too, and this will circle back to the point on fiduciary duties and the role of advisors here, is it's a new environment where incentives that were once aligned become misaligned. And I think a lot of the cost and the complexity stems from that. Let me give one example, and this is the easy one, which is debt and equity. Right? I made the point earlier about that's not good for shareholders. Well, if you step back and say, let's take this to first principles, I'm maximizing value, how could there be a misalignment of incentives between creditors and equity? When would that come into play? Well, let me give the following example. Let's say you're on a board of a company, relatively healthy, but it's extraordinarily tight on liquidity. And let's say we're approaching the zone of insolvency, but it's ambiguous. No one's done valuation work, no one has a great sense. So you don't really know to whom you owe duties, et cetera, you're just being cautious. And liquidity is tight, right? That's one of 3 triggers that can force you into a restructuring. If you're equity and your value proposition, let's say speculative, it almost becomes at that point a call option. Let's say it's at the money or an out of the money call option. If you think about, back to first principles in corporate finance in terms of value and option, one key component to that is the duration of that option, right? Extending the duration of your option. Right? So if you're looking at it from the perspective of an equity holder in a distressed situation where the potential trigger is liquidity, what are you doing? If you're just an equity holder, let's say you're not even on the board, you want to extend the duration of your option. And if liquidity is going to be the trigger, you want to get as much runway as you can. Right? So that's preserving capital at all cost. However, if you're a creditor who is certainly in the money to some degree, what does that mean for the value proposition of your claim against the company if this company is being run for liquidity preservation? Right? You can see how, as an equity holder, extending your option is where you're driving value, but from the perspective of a creditor, right, you don't want to be running the business to preserve liquidity. You want to be doing it to maximize value. So that's one that we see frequently in terms of a misalignment of incentives. One that you're probably not as expecting is sometimes there's misalignment of incentives between the board and management, right? And that's unique. That's unique to restructuring. So maybe I'll get input from Becky, who has a tremendous amount of experience of being the executive and being new and dealing with boards in these situations. If you've had experience or maybe some anecdotes of when you've seen that divergent of interest between the board and the management team.
Yeah, and I think that's one of these things that you want to just address early. You've got a management team who was counting on options or has vested and is likely going to get wiped out. And oftentimes the board members may be in that position too. But, I think that management teams need to understand that that they've got to take a look at the whole situation, maximize value for everyone. And what I like to do is put a compensation program in place early, way early, because the earlier you put it in place, the less likely it is to be challenged. So I think if you can put some kind of retention program in place 6 months, 9 months, a year before filing, you can do away with some of the misalignment of incentives that you're going to have between the board and management. And there are lots of people who are good at designing these programs where you then can apply to the court for permission to continue them, and it holds up. I don't know whether that answered your question, but
well, I think I'm sitting there looking at Brent Longnecker because he's a compensation expert, and I think the compensation committee of a board should look at that issue, face it head on, deal with it, get management comfortable that, with how they're being compensated, that they're properly motivated to run the enterprise now that it's faced with a totally different paradigm than what those options may have been, or the equity incentive programs were designed for. Now, they've got to do it within the construct of if they're heading into a bankruptcy, they got to do it within the construct of the bankruptcy code to make sure that what they're implementing is something that will work. So I think, and this is one thing we were going to touch on, and this might be the time to talk about, is when you're dealing with this situation, you look to put retention programs in place to make sure you keep your employees there, to make sure they're not looking for another job in the same industry or in another industry. And I'll tell you what experience I've encountered recently, which just totally stunned me, but there was a sort of a key employee, it was a mid-management level employee. They took a job in another industry making half the money. And I said, well, why would you do that? Well, because I can go over there, I know I'll be there 6 years from now, and it's not near as stressful. And I'm not worried about losing my job and these creditors coming in and not, knowing what the stability of the situation is. So I think managing employees, getting a proper retention program in place, an incentive program in place that's now properly designed to address the situation is something that's very important for the board to consider to make sure they have stabilized the situation and run the restructuring properly.
And I think it's also important for a compensation committee to make sure that the existing employee programs are documented. It sounds very obvious, but it's not unusual for us to go into a company and find out that there's been, a course of conduct on severance payments, for example, but it's not documented, and it's very difficult, or it's more difficult to get those programs approved if there is not, hard and fast documentation.
That's back to having a good record.
It just, yep.
Policies and procedures in place that you can support when you do go in front of the court. It's very good.
So sticking with this topic, what's different about the restructuring environment as opposed to what the compensation committee does anyways? Aren't people already motivated to drive and enhance value? What's different about this? Why would there be a new focus, if you will?
Well, I'll speak to it a little bit and then let Becky and Harry talk about it. But remember what the ISS and Glass Lewis's of the world have done to all of us in the energy business. We put us all in a small box, and you have a base salary, you have an incentive bonus that's based on some sort of incentives or key metrics, and then you have a big equity component. So most of the leadership in a company, and including boards, which we haven't talked about, that I'll come back to in a second, have this kind of compensation. When you head into a restructuring, basically what you're looking at is just the base salary. And you're worried, if you're management, do I have enough cash there to even pay my base salary going into it? So what Becky and Harry and stuff are talking about is what termed a key employee retention plan. And those are always important and sensitive conversations to have, because when you start talking about who do we really need to keep in this business to make sure that we come through the restructuring and out the other side to run a business going forward. The natural reaction is to give it to everybody. And that may not be the right answer. It may be the right answer. It's obviously the most generous one to go out there, but you need to look at it, and then you need to look at what it means to incent the chief financial officer or the general counsel or the CEO to stay away. I mean, I've seen situations where the CEO has stepped away and said, listen, you get that CURP to my employees because I need them going forward. But remember, most of the management, as Becky said, is going to lose all of their equity in this deal, and they work for equity, and that's what we've all been forced into. Just a comment to add to that. Boards of directors are in this boat too. I mean, by the time that you get to a restructuring, the boards have already worked pretty doggone hard. And what, we asked about it earlier, what's the biggest surprise? They don't realize that as hard as they've worked to the point where you get in the restructure, they're going to work about 4 times as hard once they get into the restructure. I mean, you might end up with meetings on a weekly or a daily basis when you get down to the kind of the crunch time in these restructurings. And the board, depending on, and once again, ISS and Glass Lewis, and I'm not beating on them on purpose, but they put all of us in the boat where you have a retainer, and maybe you don't get paid board fees, and all your equity, which was a big part of your compensation as a board member, is going away. So now you're working for this small retainer, and you're having 50, 60, 80, 100 meetings that you have to go to. And it becomes a full-time job when you're going through this restructure. So not only do I think you need to plan for employees, but you need to plan to incent the board the right way. And there are some things that you can do to try to switch some of that equity to cash, try to manage it properly to keep the board somewhat aligned going forward, although most board members feel a responsibility to it anyway, but you don't want them working for free, so to speak, when you're getting to these tough decisions.
Yeah, and to the group, in terms of board tenure post-restructuring, what do you typically see? Is it, there's misery for this restructuring period? What are they doing it for?
Well, you ask a good question, because a lot of times, the shareholders are going to be the debt holders at the end of the day, and the board that is there likely will not be there post-restructuring, because the shareholders, being the debt holders, the creditors, will put their representatives on this board that'll probably be a private company for some period of time after the restructuring, and the rest of the board's there. So they become, in essence, a lame duck, and it's hard to keep that board motivated. You want them not to just think about their own personal exposure in this situation. You want them to be involved, as has already been said a couple times, to look at these options, look at these different proposals that are out there, and make good, sound business judgment about what's the best way to preserve the most value for the constituencies as you move down the line.
Yeah. Brandon, one comment I'll make is, and kind of, I think, relevant to that point. Oftentimes, we'll have board members say, well, why shouldn't I just resign? I mean, why do I want to put myself through all this misery? And I think one of the comments, or maybe takeaways you'll see that Mark had is, our view is it's better to kind of ride through the storm, stay with the ship, and do the right thing. I mean, help manage through it. But one of the things you're trying to get as a result of that is a release and exculpation for you at the end of the day, not just for you, but for all the board and all the officers and other employees of the company. Get a release as part of the restructuring plan. It's not something you're entitled to. A lot of people say, well, I've got D&O coverage. Why don't I just, that's why it's there. Just go ahead and forget about that. Well, if you just rely on that and there is litigation, you've got, of course, the time and expense dealing with litigation post-reorg, which is not a pleasant experience to go through. But I think if you really do the right thing, stick with it, and you have a good record of properly discharging your fiduciary duties, you're not going to be exposing yourself during that restructuring period, because you've got restructuring advisors and lawyers, and you've got a court that will protect you during that time period. So what you're trying to protect is get that release for that prior conduct. So I think that's one of the things a board should stick with it, be a good steward, try to maximize value, try to get a consensual agreement with all the constituency, and get that release and exculpation at the end of the day, so they can kind of close the chapter and not have that hanging over their head while the statute of limitations period runs.
And make sure the tails on the D&O
Yeah,
policies
the other
are
thing
purchased.
is, obviously, you do want to make sure they maintain D&O coverage, and you want to get that tail coverage for the, whatever it is, 6 years. It depends on the jurisdiction you're in on how long that statute of limitations tail period runs. But
What are your thoughts on supplementing the board in advance of restructuring? To the extent you don't have a board or board members that have been through it before, what are your thoughts on bringing on somebody
Well,
new?
you've got a couple of issues there. One issue I think you have is if you've got conflicts at various subsidiary levels, given the capital structure you have, where you may have one entity has claims against the other, and the outcome of those claims may dilute or impact distribution to the creditors at those relative corporate silos, you may need to bring in independent directors to address those peculiar conflict claims that exist at that level. Because if you don't do that, you may find in the bankruptcy that a court will say that's a flawed process and give standing to one of the creditors' constituencies at those levels to pursue them. Separate and apart from that, I think if you can bring on sort of a fresh director, if you can find one that's willing to come on that's experienced in restructurings, I think it's certainly worthy, effort to consider that. I don't know that a lot of people have an appetite coming into a distressed situation, given what Bill's talked about in terms of time commitment, because it is, we have weekly update calls, sometimes daily with board, not always board meetings, but calls with, when we get in these restructurings. And let me tell you, it's a real burden on the directors that are, those individuals that sit on those boards.
I think the advice that Harry's given is right on point. A couple things about this. One, as I said earlier, lots of boards do not have any experience in a restructuring process. If you've been a former chief financial officer or a former CEO, that doesn't qualify you to understand how the restructuring process works. You need these advisors, but I also think the board needs somebody there. So if you bring, we talked about earlier setting up a special committee, but if you have a special committee, maybe you can find somebody that will come in and kind of be the liaison, lead that group, really involve the board and help marshal the resources of the board so that they have a different comfort level rather than just, once again, ceding it to the advisors, because the advisors are there, but you need somebody that's on your team, so to speak, as you go forward. One other comment to add to Harry's about staying on the board. There is a real tendency and a real desire to say, I don't want to go through this process as a board member once you head into restructuring. But I think that, just to put it in a general perspective, being inside the tent and watching the process as opposed to being outside the tent is a much better way to do it. It's not comfortable going through it, but it's even more uncomfortable if you're on the outside and you don't know anything and you're watching and you're hoping that you don't have any exposure going through. Not the least of which, you're going to learn a lot when you go through one of these things, and you'll get out the other side, and hopefully, in every case I've been involved with, there's been no litigation, and we've walked out because we've had the right advisors, we've run through the process, we've created the right kind of record, and we've ended up with the release at the end of the day going forward. And remember, if you've done your business judgment right, you've stayed involved, you've stayed informed, you've really looked at the alternatives, and you've signed off on the plan, and that plan ultimately gets signed off by a federal judge, it is very hard for somebody to come back and question you once a federal judge has signed off on this is the right plan for the company.
So I can tell that we have several members of the audience who have been through this before by the stack of questions and the level of detail. What I think I may do is turn to addressing, we've touched on a few of these as I've been receiving them. Maybe I'll turn to a few direct questions, and this would be a bit early just because we can try to work through these, because these are very pointed and very articulate questions. So I'll open it up to the group. Here's a good one. Experiences with the board in terms of its D&O insurance, which we talked about before. Is that an asset of the company? And have you dealt with situations where there's been a petition to the court to deny the defense cost advances to the board because the D&O policy is an asset of the company that may fall to
Okay, the policy, I think it is an asset of the company. I mean, it's a contract the company entered into. You've got to look at the specific policy to see how it's drafted. I think most policies I've seen today, we're faced with that situation right now with two cases we have. They've been written in such a way that the directors are protected and those costs are covered. I'm not a D&O expert, but I do know that in the past there have been instances where maybe there was an effort to preserve all that proceeds of the policy for the benefit of the estate and therefore creditors and denied directors. But I think if you have a good insurance broker representing you, that they should have that type of coverage that makes sure that sort of risk for a director or officer is minimized.
And a follow-up question that's somewhat related. Is a good D&O policy enough? I mean, I would add your point earlier that the releases, if it is through a Chapter 11, those releases are important for conduct prior to the bankruptcy. Like you mentioned, during the bankruptcy, you have a court saying essentially, yeah, decision approved, if you will. But is a D&O policy enough, or is it D&O policy with releases enough? Are there other supplements to that?
Well, releases are critical. I mean, that's, but I don't really know that much more you can get, but in addition to a D&O coverage and a release. I will say that if there's some sort of a fraud claim involved, then that opens up a whole another issue. But if it relates to a sort of breach of fiduciary duty or some sort of a negligence type claim, I think a release, exculpation that's typical in the plans and the D&O coverage should be as good as you can get. Now, one tension you will find, and you'll see it in most cases, is creditors committee goes, wait a minute, we don't mind capping any exposure to the D&O policy limits. Why should we give them a release when we may have a claim whenever there actually is, we could recover something of that policy and get some something to come into creditors? And what we try to do in that situation is say, look, do your diligence and see if you think there is a claim. That's part of your job as a creditors committee, is to see if there is a claim. We're not aware of one. If you think there is one, ferret it out now. And so you kind of put the onus back on the committee to do that. And if you've run a good process and you've got a good record on that point, the court will kind of help push back on that point as well. They won't force that point. What you may find yourself doing is negotiating with the insurance carrier to go, look, your defense cost would be $2 to $5 million if they bring a claim. Why don't you throw in $3 million? Because that's really kind of what this is anyway. This is a predator mercenary hedge fund doing a shakedown on the insurance company, throwing you $3 million and we're all good. So you'll see that done sometimes too.
But there's some critical points in there, because if you let a committee get out too far ahead of you and then you have a carrier that denies coverage because it's a claims made basis policy and it's a claim that you should have known about, you didn't report it, so the coverage isn't, in effect. You have to be very, very careful, and until I ran into this a couple of years ago, I really wasn't aware that all D&O policies are not equal, that you really do need to read the language in the policy, what the exclusions are, and it's perfectly fair for a board to ask the broker to come in and make a presentation, and there are companies that specialize in comparing policy terms. It's money well spent to have that done.
And there's actually companies that specialize in providing tail coverage. They'll come in, they'll do a complete review of your existing coverage and maybe even try to supplement whatever holes might be there, obviously for a premium, and also to provide tail coverage. And it's a good practice tip. Do as much of that as you can pre-filing, so you don't need court approval to make those payments, and get that in place before you're in the Chapter 11 where you might need court approval to do something like that.
I'm gonna go because we have so many questions and we're not gonna be able to get to them all, so I apologize in advance, but I'll try to combine a couple in terms of some themes I'm seeing through these. One, I think, Becky, this may be appropriate for you in terms of, as you often come in to supplement management teams or replacing them, there's a couple questions about, one, the catalyst to consider before bringing that person in, whether to replace current management or supplement the management teams, and then the interaction between that new management team or member and the board.
My preferred role, if I'm going to be, part of management and accept all the fiduciary obligations and the like, is to either be the chief restructuring officer, or oftentimes a CFO will leave and I'll take that role. The catalyst is whether you have the manpower to get through a restructuring and still keep the company going at the same time. And I keep talking about, the focus on the company's operations, because I've seen so many situations where the company let the process take over instead of controlling the process. And again, I think that every situation is going to be different. It's fair for a board to have an honest conversation with its management about, are you up for this? Do you want to step aside? Do you want to come back in? But there's not any single catalyst. It's very, very, situation specific. But it's a dialogue that should be had.
Do you have anything to add?
Well, I think Becky's right on point. I have seen it in a couple of different situations. One where the management team really didn't have the resources, as Becky said, and bringing in a chief restructuring officer that really gave the creditors confidence that the company knew what its cash flow was during this process was helpful in negotiating with the other side. And then there are situations where the board, for whatever reason, and you all been in board situations where you know that there's a weakness at the chief financial officer role or the CEO role or the operations role, whatever it may be, and they just want to bring somebody else in to help the process, and that becomes sometimes contentious in terms of what's there. And really it puts the advisors that step into those roles in a tough situation. But you got to make sure that you can get through the process. The demands on the management team are just hard to relay to you if you haven't been through it. And the ability to continue to run the business while you're running this process is really difficult, because you have, once again, depending on how complicated your capital structure is and how many other advisors you're dealing with, you're not just dealing with yours, you're dealing with 5, 6 others that are out there, and the requests that come in are just huge, and you got to have a process to deliver all that. But if you're going to get out the other side and get a reasonable valuation for your business, you got to make sure the business is run. So as a board, you want to assess that honestly and bring in the talent that would help get you through it.
Our time is coming to a close, but I can just quickly, in terms of some of the questions we haven't been able to get to just as an indication of the complexity, and some of these questions are so good. We wish we had 3 more hours to go through them, but just to give you a sense of the complexity, one of the questions was about preference payments. So the 90-day period before you file for bankruptcy, making payments that aren't in the normal course of business, that can be looked back on as a preference, right? So this is not typical issues you deal with, and understanding what is and is not a preference. There was a question about defining what is in the ordinary course of business. Another question about bank regulation in Chapter 11, the Yates Memorandum and the impact on this. These are some detailed questions, and I think for the most part, most of us are around afterwards to answer some of these. But I'll end on 2 sort of higher level, more general ones. The first one I think we can deal with relatively quickly, but I just like the question, is should board members be concerned about the paper trail in terms of their involvement and their engagement discussing vacation?
Discussing vacation.
Before we start a restructuring process, we always have a protocol where we sit down with the board and we go over, review with them what fiduciary duties are. We have a whole spiel we give them. We also talk with them about how to handle note-taking, how to handle emails, and remind them that any email traffic that may be sent, they may find that thing winds up as an exhibit at trial, and something that you might think is the most innocent comment made can get blown out of context by a good trial lawyer and be something that you regret you did. So, the scrutiny, as you put it, when you're in this situation is such that you've got to be very mindful of the record that you've got, that you're going to be subject to discovery and depositions yourself as a board member. And I forgot the last point of the question there.
It was just about vacation. If someone's saying, I'm out this week, is that something that's sensitive that a good trial attorney could?
Well, I mean, God, Yeah, I think, well, if you've got a board, you're talking about, this is for
Board
the
member.
board.
Board member saying, I'm out of pocket, I'm
I
going
forgot-
to
Well,
Italy.
as long as you, I think as long as you, if it's, look, you know what, you still got a life to live. I mean, I wouldn't want to make a habit of that. I think it would depend on how critical the decision is that they're faced with. But look, you've got a board that's there, that's, if you got a quorum, and you've otherwise got an engaged board, look, you're entitled to, to act as a quorum. So I
Exactly.
wouldn't make, I wouldn't make a habit of it. If it's a one-off deal, it's probably okay, but,
I would just quickly say to that one, you're humans. You're going on vacation. That's on your advisors. Let them know in advance when you're going. I don't think there's a sensitivity to it.
yeah, and you can obviously, we update board members and management one-off all the time when they can't participate in updates or meetings.
Last question, and I'm going to keep the responses super short because we're out of time here. So your answer has to be just one number. Here we go. How many more bankruptcies in the energy sector are foreseeable in Texas during 2016 and 2017? I just want a number. Bill?
80.
There you go, 80.
I'm thinking 75.
There you go.
It's over under on this.
It's like a
I
game
was-
show.
I was going to say 50, but now I'm going with 70.
I'm going to go 0 because this crew is going to keep us out of bankruptcy. How about that?
Can I just add one to that? The reason I said that is that boards that you're on today, there are so many in the upstream in the service industry that are going through restructuring. You have to think today that all of that group that are your peer group and your competitors are going to have a completely different capital structure coming out the other side. And if you haven't restructured your capital now while everybody else is doing it, you're not going to be competitive on the other side. So you need to kind of think about it in terms of where you're at. Everybody's doing it. It's not anything that any of us want to get into, but you really should think about, man, I should go and try to do something consensual now, maybe not go through court while everybody's doing it, and you create a better competitive situation for you because you might be the party that's in 11 if you don't do this now when everybody else is restructuring and going down the path.
Thank you very much. And apologies to those we didn't get to your questions. Appreciate it.